Hey everyone, I want to discuss the copyright strike system on YouTube from a legal perspective, in response to the situation with the YouTuber Tren Black and his allegations about other YouTubers, Matt Tran and TechLead, and what happened there. If you haven't seen Tren's video, I'll post it in the description. Please give it a watch because I'm not going to summarize it here. In this video, I'm only going to take a look at the actions associated with TechLead, and the reason for that is because the copyright system and the DMCA has a wider implication for YouTubers and content creators everywhere, even if that conduct is, less morally repugnant than what Matt Tran is being accused of. I'll probably make a separate video for Matt Tran's conduct later. So TechLead had been copyright striking Tren's critical commentary videos about him, including this most recent one that accused him and Matt Tran of misconduct. This situation, where people can just copyright strike videos about them at will, even when they are being used as potentially fair use, is a larger problem on YouTube. Is there nothing that can be done about it? Let's take a look at the law that regulates this area. Title 17 of the United States Code deals with copyright, and the DMCA amended it to extend to the internet. We'll call this the Copyright Act. So Section 512 of the Copyright Act is called Limitations on Liability Relating to Material Online. What this section does is set up a framework so that whenever there's a copyright infringement taking place online, the parties, meaning the copyright holder and the user, don't need to resort to suing each other all the time and clogging up the court system. Instead, they can handle it outside of court. In this framework, Section 512 sub C lets YouTube avoid copyright infringement liability for storing users' content if, among other requirements, it expeditiously removes or disables access to the content after receiving notification from a copyright holder that the content is infringing. So this basically means that YouTube has to take down a video quickly after someone claims it's a copyright of their work. Section 512 sub C3A sets forth the actual elements that a takedown notification or DMCA takedown procedure or a copyright strike must contain. These elements include 1. Identification of the copyrighted work, so the original. 2. Identification of the allegedly infringing material, aka the video by the person using the original. And 3. A statement that the copyright holder believes in good faith the infringing material is not authorized by the copyright owner, its agent, or the law. So once they receive the takedown notice from the copyright holder, YouTube notifies the user of the takedown, and then the user has the option of trying to bring back the content by sending a counter notification. And that also includes the statement of good faith belief that the material was removed or disabled as a result of mistake or identification. Once YouTube receives a valid counter notification, it tells the copyright holder of the counter notification and restores the content in 10 to 14 days. Unless the copyright holder tells YouTube it has filed a lawsuit against the user for the infringement. This is called the DMCA putback procedure. So looking at the takedown procedure, steps 1 and 2 are pretty trivial. If you think your work has been infringed, you can look at someone's video and say, yup, that's my video or content in their video. Step 3, of course, is where it gets complicated. You have to make a statement that you believe in good faith that the infringing material is not authorized. Now, of course, you as the copyright owner or your agent haven't authorized it, unless you've sold the license or made it usable as a Creative Commons license. But what about whether you believe in good faith if it is authorized under law? That's what the United States Court of Appeals 9th Circuit in 2016 had to look at in the case of Lens and Universal Music. They had to look at whether copyright holders must consider whether the potentially infringing material is a fair use of a copyright under Title 17 United States Code, Section 107, before issuing a takedown notification. They stated, "We agree with the district court and hold that the statute unambiguously contemplates fair use as a use authorized by the law. Fair use of a copyrighted work is permissible because it is a non-infringing use." Why is fair use non-infringing? What even is fair use? The Copyright Act allows you to take copyrighted work and use it in your content for purposes such as criticism, commentary, news reporting, teaching, scholarship, or research. And using this copyrighted work in these ways does not constitute infringement. Fair use permits and requires courts to avoid rigid application of the copyright statute when on occasion it would stifle the very creativity which that copyright law is designed to foster. The Supreme Court has found that transformative uses of copyrighted works lie at the heart of the fair use doctrine's guarantee of breathing space within the confines of copyright, because such works generally further the goal of copyright to promote science and the arts. Now, to determine whether a specific work falls under fair use, it's not straightforward. It's a balancing act of a bunch of different factors. The first factor is the purpose and character of the use, meaning whether and to what extent the new work is transformative. and it includes whether such use is of a commercial nature or is for non-profit or educational purposes. The second factor is the nature of the copyrighted work. This means taking a look at whether the original copyrighted work was imaginative, creative, and original, or more informational, and whether it had been published before or not. The third factor is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. For instance, is it necessary to copy verbatim and in its exact form from the original work for the new work's purpose? And the fourth factor is the effect of the use upon the potential market or value of the copyrighted work, as in, would it substantially adversely impact the market for the original and its derivative works? However, importantly in the context of videos like trends, it should be noted that for this factor, market harm caused by effective criticism that suppresses demand is not considered. Instead, the only kind of harm that's recognized is market substitution, i.e., where the new work diminishes demand for the original work by acting as a substitute for it. And so, in making a determination whether a specific video falls under fair use, a court would have to take all of these things into account and then decide on the balance and weighing of these factors if it falls under fair use. So now going back to the DMCA takedown procedure set up in the Copyright Act, the court in the Lenz decision held that we conclude that because Title 17 United States Code Section 107, this is the part of the Copyright Act that enshrines fair use, created a type of non-infringing use, fair use is authorized by the law, and a copyright holder must consider the existence of fair use before sending a takedown notification under Section 512 sub c. Going back to 512 sub c, remember the elements? So for element 3, when you are trying to take down someone else's video, you have to believe in good faith that it is infringing your copyrighted work. And as we established, if the video is in fair use, it cannot be by law infringing your work. Therefore, if you want to take down a video, you must believe in good faith that it is not in fair use. Now here's where it gets a little tricky. What does believing in good faith mean? It's not whether we or a court believe that a certain video was fair use or not. It is whether or not the copyright holder believes in good faith, whether it was fair use or not. This is what's called a subjective standard in law. It is what is believed in that specific person's head. Now you might be thinking, well, that's stupid. There's no way we can know what's going on in someone's head. And you're right, we can't. But not to worry. In the common law, when we are dealing with subjective standards, like what was the defendant's intent in a murder case, or other issues when dealing with someone's personal knowledge or their belief, we are allowed to make inferences from what they say and do in the circumstances. Now you might be thinking, well, what if based on what they say and do, someone just subjectively believes that every video that makes use of their video is not fair use? What if that's their subjective belief? They are just completely an unreasonable person. Would that mean that they are entitled to make a legitimate takedown notice to every video? Not necessarily. Practically speaking, someone who knows about the takedown system likely has some knowledge of what fair use is. And the procedure that you go through on YouTube to do it also would inform them about it to some extent, that if the video that they are trying to take down is fair use, it's not an infringement. And so it is up to them to investigate the video at hand and then form a belief, in good faith, about whether it is fair use or not. Of course, this is different from the copyright holder making a mistake though. A copyright owner can make a valid takedown notice because of an unknowing mistake, meaning about whether that video it's trying to take down is fair use or not, even if the copyright owner acted unreasonably in making that mistake. So you are allowed to have the wrong belief in that sense. So then, does that theoretically leave open the possibility that some ignoramus who, whenever they see their name or picture mentioned in a video, believes it's an infringement and not fair use, can make takedown requests? No. As the court says in Lenz, because the DMCA requires consideration of fair use prior to sending a takedown notification, it must be determined whether the copyright holder's actions were sufficient to form a subjective good faith belief about the video's fair use or lack thereof. So them just having this belief that it's not fair use is not enough, even if it's their subjective belief. They have to take sufficient action to actually form a belief that it's not fair use. This means that the copyright holder cannot be willfully blind. So if you think that a video may likely be fair use, because it's for instance transformative criticism or commentary, not trying to just use your clips untouched with no valid purpose, and you purposely don't even watch it, to avoid finding out whether it is fair use or not, then you are being willfully blind. And even if it is your belief that it's not fair use, you haven't taken enough steps to make such a belief. Thus, your takedown notice is not valid under the Copyright Act. But in all likelihood, this doesn't apply to someone like TechLead, who is an ex-employee of Google, who has been on YouTube for many years, who touts his intelligence and wealth derived from his intelligence, regardless of exaggeration for comedic effect, he can't plead the role of the ignoramus. We could take a look at his actions and statements and most likely infer that he knows about how fair use works, and that he has watched Tren's videos, to determine with enough diligence whether he actually subjectively believes those critical commentary videos are fair use or not. In fact, we have some such evidence in the message he sent to Tren, in Tren's video. In this message, he makes no mention that his issue with Tren is that of someone infringing his work, the entire purpose of the takedown request system permitted under the Copyright Act, but rather that he is upset by the nature of the criticism. This is akin to a copyright holder in Online Policy Group and Diebold, who was found liable for misusing the DMCA's provisions, quote, as a sword to suppress publication of embarrassing content rather than as a shield to protect its intellectual property. The defendants in that case threatened a lawsuit if the material was not taken down, similar to how TechLead here threatened a public social media post to call Tren out if his video wasn't taken down. So we may have possibly made out an abusive DMCA takedown. Now what? What can the person who made this fair use video do in response? Section 512 sub F deals with this. This section means that if the copyright holder knowingly misrepresented that they had formed a good faith belief the video did not constitute fair use, they are liable for any damages. You can sue the copyright holder for money. And because subsection F says any damages, the courts have found that this isn't limited to just monetary losses, like your costs and lawyer fees of taking this matter to court. Any damages means any damages. This could be damages for emotional and mental harm, and even includes nominal damages, which is that if you get nothing else, you at least get damages just for vindicating your rights. Now, while it is great that once you win in court, you could potentially claim damages for anything against the copyright holder, the discouraging part is, of course, that you even have to go to court in the first place to get this remedy under Section 512F. This means larger creators, especially channels of corporations, are more likely to be able to assert their rights because of their economic power and connections as opposed to smaller YouTubers. So is this a good system to have, to allow these DMCA takedown and putback battles to occur on YouTube? In Tudor and Crossley Corcoran, the court remarks this system under Section 512 was Congress's express intent of creating an expeditious, rapid response to potential infringement on the internet. Undoubtedly, abuses will occur, as is the case with almost any system that permits legal self-help. For these abuses, Congress provided a remedy in Section 512 sub F. If experience ultimately proves that the remedy is weighted too heavily in favor of copyright owners at the expense of those who seek to make fair use of another's intellectual property, the resetting of the balance is for Congress and not for a court to strike. The idea here being that if we want to change the system, we likely need to see a change by lawmakers. And if you've noticed, I've barely mentioned the role of YouTube itself in the system. And that's because it is a service provider under the Copyright Act by virtue of hosting this content online. But other than that, it's simply a conduit for the DMCA system, by being what's called a safe harbor, which means that in order for it to protect itself against copyright liability, it has to follow this DMCA takedown notice system. If it started to, let's say, implement its own more investigative system that wouldn't allow for quick video takedowns on the notice of copyright holders, it would lose its legal protection. This means that YouTube would expose itself to considerable amount of lawsuits. Now, the unfortunate reality is that the law is often slow to change. Technology will likely change faster, and hopefully, YouTube can get to the point that it doesn't need to rely on the DMCA for legal protection, but can handle it in itself in a manner that's more fair but also quick. Now, one area that I glossed over was this requirement to provide your personal information when you're making a counterclaim after your video was taken down. As you can see, this is a requirement by law under Section 512 sub G. Now, part of the reason that this is in there is to make it easier for the parties to identify each other, and if they want to proceed with a lawsuit, to have that information. But of course, it presents this huge privacy concern that your information can be taken and disseminated against your will. This is what Tren Black believes happened to him when TechLead made those copyright strikes against him, that TechLead then used that information that he was forced to provide on the counterclaim to release his real name. Now, this could potentially be a place for YouTube to step in. For instance, YouTube's user agreement could include a provision that the personal information disclosed under takedown notices and counter notices can only be used to contact each other or to initiate legal proceedings, and that any other use of it could result in the termination of a YouTube account. This could still possibly comply with the DMCA system by allowing for the takedown and counter notice system, but also allows for the addressing of privacy concerns like the potential for doxing as well, by deterring YouTubers from using that personal information in any other way. This is something I hope that YouTube will look into more and address. Anyway, I hope that this cleared up some things about how the copyright strike system works and what's the law behind it. Let me know what you think about this system in the comments. Thanks for watching.